The state after a sentencing hearing on Ms. Bell, does the state have any evidence it wishes to offer in aggravation? Mr. Carter, Mr. Frost, do you have any evidence you wish to offer in mitigation?
I would just like to state that Ms. Bell's crimes, as found by the jury to be guilty, were more of her being a willing victim, and that spilled over into what happened as to her children. It's terrible, and it's extremely sad that happened. But I don't think that, and obviously she was not charged to the level that Mr. McNab was, and I would just ask the court to take those factors. She didn't have the opportunity of having an upbringing, as I think I discussed in my closing. She had no role models for that. She was suffering from addiction and abuse, and should she have done something? Yes, she should have. She didn't, and that's what led her here. And but I think that there's through courses, coping mechanisms, things that she might learn through prison classes and afterwards, there would certainly be the possibility of her being someone who could be a productive member of society if she were to embrace some of those things and put them to use in her life. So we would ask the court to take those into consideration.
Does your client wish to make any statements?
I didn't do this. Y'all know I didn't do this.
Well, you and I had a conversation back in Chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you anticipated the murder, wasn't that you planned the murder, any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNab to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put in there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying, your child's dead from a rattlesnake bite. Why would you put it in there and you bonded? Well, I just wanted her to enjoy nature, have an appreciation of the outdoors, without appreciating the danger. Now, I'm sorry, but for you to go around chasing McNab, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, they're out everywhere. The mother bear, they're so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNab over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNab, is that, like most criminals, you have this version of what a good mama is that is so far from the norm that, you can go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I know of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up. They don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. Let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Right, turn that down some.
Okay. On count 1, I'm going to sentence you with 30 years, with the first 15 years to be served in confinement in the state penitentiary, the remaining time on probation. On count 3, I'm going to sentence you to 10 years in confinement and run at the same time as count 1. Now, do you understand your 2 sentences? And let the record reflect she's nodding her head slightly yes. And Ms. Bell, I'm going to give you the following rights that you have. Within 30 days, you have a right to appeal this case to the appellate level. You may start that process with a motion for new trial, which I'm going to direct the attorneys to file, just a skeleton general motion.
Yes, sir.
If at the time you decide, Ms. Bell, you can allege that your attorneys did an ineffective job. They just didn't do a good job. It has to be brought up at its earliest moment. The attorneys do not get their feelings hurt if you choose to do that. And we would appoint a conflict attorney to come in and take over the appeal. Do you understand me clearly about that? I need you to stand up first off. I need you to start verbalizing.
I understand.
Okay, because she's making a record on all this. It all has to be taken down. I'm also going to advise you that if the case is appealed to the appellate level and the appellate level affirms that case in the verdict and sends it back down for the service of the sentence, you have 4 years from the date it comes back down to file what is known as a writ of habeas corpus. That means I'm being illegally detained unconstitutionally, and I want my body out of jail. But it has to be done. It's a time-sensitive thing, and you only have 4 years to do that. You understand that clearly? Yeah, do you have any other questions? Okay, take her on. Yes, ma'am.
The max on count 3 is 5.
Is this the kind of intelligence I can expect from you, O'Connor?
Ready to publish your brilliant ideas? Start a blog and so much more. Build a website that can.
No way you're gonna put that on. I don't care if you have to put a gun to someone's head and blow your cover to smithereens.
And finally, count 8, considering the death of another, you have to be sentenced on that too. Is that 10-year sentence?
Yes, sir.
Okay. Is everybody ready?
Yes, sir.
Bring out Mr. McNab. Are y'all ready for the sentencing hearing? You may be seated, Mr. McNab. Let's turn to the sentencing hearing. And does the state have anything it wishes to offer in the way of aggravation?
Yes, Your Honor. We have several certified copies of convictions as well as one witness that I believe is on her way here in the courthouse. The first would be State Exhibit number 137, which is a certified adjudication order from juvenile court, case number 107-01J-0625 and 107-01J-0611. That is for disorderly conduct. The defendant was adjudicated delinquent for that offense as a juvenile in June of 2001. State's Exhibit number 138 is also an adjudication order for case number 1007-00J-1281 and 1354, where the defendant was adjudicated delinquent for simple battery as a juvenile in January of 2001. Also case number 107-99J-702. This is State's Exhibit 139, which is an adjudication order from juvenile court for simple battery from November of 1999. We also have a Superior Court conviction out of the Superior Court of Bartow County. The defendant was convicted in Bartow County for theft by taking, entering a motor vehicle to commit a theft, criminal damage to property, burglary. He was sentenced on case number 2007-1989. And that was in October of 2007. That was State's Exhibit number 140. State's Exhibit number 141 is a criminal conviction for the Superior Court of Newton County, case number 2013 CR 1263-5. Defendant was convicted of theft by shoplifting and giving false information to a police officer. He was adjudicated guilty or sentenced on this particular case in the October term of 2013, and that's again states number 141. Also states number 142, which is a Superior Court of Newton County conviction on case number 2015 CR 02-5, where the defendant was convicted of obstruction of an officer. That again was a sentence from the January term of 2015. State offer states exhibit number 143, which is the Superior Court conviction out of the Griffin Judicial Circuit, where the defendant, Christopher Michael McNab, was convicted of obstructing and hindering a law enforcement officer felony, driving while license is suspended, driving on the wrong side of the roadway, speeding, stop sign violation, and failure to maintain lane. And that was in August of 2001. State offers exhibit number 144, which is a conviction out of Coweta County on case number 2013-0190. And there the defendant was convicted of one count of theft by taking, and that was in, looks like February of 2003. These are all certified copies of convictions that the state has for Christopher Michael McNab, and I'm showing it to Mr. Carter.
Judge, I have no objection to exhibits 140 through 144. I do object to the misdemeanor juvenile delinquent, juvenile adjudications.
Judge, I know the law is clear that anything can be used in aggravation, so juvenile adjudications are admissible. I have one witness.
Well, let me finish with this first, Ms. Zahn. I'm going to admit everything into evidence. If it makes any difference to you, the misdemeanors mean nothing to me, Mr. Carter. And I would not enhance sentencing at all because of the misdemeanors.
Yes, sir.
Now, Ms. Zahn,
Your Honor, the state calls Priscilla Faulkner, Dr. Priscilla Faulkner.
Night.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give in the matter now pending before this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you. Please state your name.
Priscilla Faulkner.
And you are a doctor?
I am.
And a doctor of what?
Psychology.
I want to draw your attention back to October the 14th of 2017. Did you have the occasion to go to the Newton County Detention Center to have contact with Christopher Michael McNab?
I did.
What was the nature of that contact?
Your Honor, I'm going to object because the notice of this aggravation was only provided to me last night.
why is that a concern?
Because it should have been provided prior to trial, and it was only provided last night.
Ms. Zahn?
Well, Judge, I learned of it yesterday, and I reached out to Dr. Faulkner and spoke with her to confirm the veracity of this. I let Mr. Carter know last night, and Mr. Carter notified me this morning that he was already aware of this. So he's known about this, and there's no prejudice or harm because he's known.
Is that correct, Mr. Carter?
I was aware of the situation. I was not aware that it was
Turn that
intended to be
volume
used
down.
as aggravation.
Before you do anything.
I'm going to allow the testimony.
Okay. What was the nature of your contact with Mr. McNab?
I was evaluating him at the request of Newton DFACS.
And did you have the occasion to be working on your computer down there at the jail while you were talking to him?
I did.
And at some point in time, did Mr. McNab tell you to look up?
He did.
And when you looked, where was he at in relation to you?
He was probably an inch or two away from the glass, right in front of my face.
So were you separated by glass?
We were separated by glass.
And what did you see when he asked you to look?
He was wearing a turtle suit, which is something that prisoners are wearing when they're on suicide risk. And he wasn't wearing clothing under that. He had pulled up the turtle suit and taken out his penis and was masturbating.
And did he masturbate to completion in your presence?
He did.
Thank you. Those are all the questions that I have.
No questions, sir.
I got a question. Can I address the court, please? I just got one thing I want to say, and that's it. I'd like to say it in front of her since she's the one accusing me.
Is there any further evidence in offering of aggravation?
No, Judge.
Mr. Carter, do you have any evidence to offer in the way of mitigation?
I believe Mr. McNab would like to address the court.
Okay, you may do so. You may stand up and address the court.
I just like the court to know, as well as everybody at home, since this is being broadcasted for whatever reasons, that I did have on a turtle suit and it velcros, and it wasn't on properly, and it didn't fit properly, and the velcros were not on good because they don't stick, because they've been used for so many years by so many different people, and I was not masturbating at all in front of her, period. The thing fell off when I stood up, and that was it. There was none of that, and I would have liked to have told her that, since she was the one making the accusation, since I'm pretty sure by the law states that I have a right to confront my witnesses who accuse me of doing wrong. So I felt like I wanted to say it in front of her, since she was the one up here slandering me. And that's all I got to say.
You sure you don't want to talk about the sentencing and all of that? That was the only thing you wanted to tell the court?
I mean, I haven't heard anything about a sentence. I was just
About the sentence
commenting on that. I
for the
understand that.
charges. I just wanted to know if you had anything you wanted to say to the court.
I mean, I got a lot to say. I got a lot to say, but I'm not going to be able to say half of it.
I don't know, because I don't know what you're going to say.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time. I feel like there was things that were allowed to be said that should have never been allowed to be said. It didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. So that doesn't make sense either. And, just to let the record show that I don't think I ever put my hands on her in front of those kids. And I just don't feel like just because somebody has domestic issues with the female in their life that they love, that they were just able to just say, oh, he don't love you and all that stuff just in front of everybody or whatever, which doesn't matter. But I just don't understand how you find somebody guilty of doing something to a 15-day-old baby, because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it. I never would. I don't believe in it. I was beat as a child, and I don't agree with it at all. And I would never do it. I would never do this. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay. So they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement, consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal
It'll be filed.
on this case. I'm going to instruct Mr. Carter on behalf of you to file a motion for a new trial to make sure your rights are protected. If you wish to allege that Mr. Carter did not do an effective job, then we'll bring in another attorney to handle the appeal so that issue can be raised, and that's fine with Mr. Carter. He takes no offense.
I think he did an incredible job.
Well, that's fine. I'm just indicating to you that in order to claim your attorney at trial was ineffective or did not do a good job, you have to raise it at the earliest moment, which would be here.
I won't be filing anything against my attorney.
That's fine. I also want to inform you that if the case is appealed, if the Supreme Court of Georgia affirms your case, you have 4 years from that date. The affirmation is made in what they call a remitter. The case is set back down here to file what is known as a writ of habeas corpus, claiming that your body is still being held illegally and unconstitutionally. It has to be done within 4 years of that date. 4 years and 1 day, they would not